Greetings and welcome to our program, Repatriation as a Human Right. I'm Greg Johnson, Director of the Walter H. Kapp Center for the Study of Ethics, Religion, and Public Life here at the University of California, Santa Barbara. The center is pleased to welcome our audience and our esteemed presenters, whom I'll introduce shortly. First, let me sketch how this event fits into the year-long symposium that we're hosting. The symposium is entitled Ethics in Place, Indigenous Peoples and the Future of Principled Democracy. Let me pause there. Maeve, could we please pull up the flyer for the audience? Thanks. And while people are tuning in, just letting you all know, the webinar function I know is frustrating. You can't see who else is here, but already we have more than 60 people signed on, and I'm sure we'll have yet more as we just got going. So thank you all for being here. So again, Ethics in Place, Indigenous Peoples and the Future of Principled Democracy. I think that title speaks for itself. We're talking about accountability to Indigenous peoples, their lands, their bodies, their futures. This is so important at this moment in our collective reckoning. I think that goes without saying again. All year, we've been focusing on this topic from various angles. You can see here the remainder of our winter schedule. Please join us on February 11th as we host Suzanne Schoen-Harjo and Michael McNally as they speak with us about sacred land protection. Then later in the quarter, March 4th, we have Kristen Carpenter and Justice Gregory Bigler speaking with us about implementing the United Nations Declaration on the Rights of Indigenous Peoples. This is really an A team of people speaking to us about these most important issues. The spring schedule is still being put together, but I promise it'll be compelling as well. So again, please tune in. I want to draw your attention also to another event the center is hosting soon. On February 9th, 6 p.m., we'll be having a session on white nationalism and free speech. Another topic of urgent import, as we've seen all too clearly of late. Relatedly, I want to make sure you know that we host a blog here at the Walter Kapp Center. It's on our website. It's called Straight White American Jesus. Bradley Onishi and his colleagues run this blog, and it's about, again, white nationalism and Christianity and the politics of being human today in this country. Right now, I want to thank the people who make events like this possible at our center, our donors and collaborators here on campus, including the American Indian and Indigenous Collective. And most of all, our staff here at the center, Maeve DeVoy, Alma Mendoza, and Madden Westland. Thank you all for making this happen. Now I'd like to give a land acknowledgement. We know how important these acknowledgements are, doubly so in a context like this, where we're talking about human remains, institutional accountability. The very building in which I sit has Chumash human remains in it that await repatriation. So here we are, here I am, University of California, Santa Barbara, on the unceded lands and territories and waters of the Chumash peoples. That needs to be said, that needs to be addressed. Institutional accountability needs to be our watchword. And I hope this program goes some ways down the road into making that good on that promise. And in my capacity at the Kapp Center, I look forward to being involved in conversations to move repatriations forward here at UCSB. Now I'd like to turn to introduce our guests. And let me bring here. Some of you may know that this is a topic that I've worked in for some years. And so when I put together this group of speakers, I knew exactly who to go to, who would be the A team for this particular conversation. And it's the three people we have with us. So first, Walter Echohawk is president of the Pawnee Nation Business Council. In 2018, he was Dan and Maggie Inouye Distinguished Chair on Democratic Ideals at University of Hawaii Law School. He has authored several books, including The Sea of Grass, In the Light of Justice, In the Courts of the Conqueror, and Battlefields and Burial Grounds. A Pawnee Indian with a BA in political science from Oklahoma State University and a JD from University of New Mexico, he practices law in Oklahoma. As the staff attorney of the Native American Rights Fund from 1973 to 2009, he represented Indian tribes, Alaska Natives, and Native Hawaiians on significant legal issues in the modern era of federal Indian law. He litigated Indigenous rights pertaining to religious freedom, prisoner rights, water rights, treaty rights, and reburial repatriation rights. Echo Hawk is admitted to practice law before the US Supreme Court, Colorado Supreme Court, and Oklahoma Supreme Court, among other jurisdictions. In many respects, he stands as the moral force behind the contemporary repatriation movement and is a profound honor to be hosting him tonight. After President Echo Hawk presents, we will have Professor Angela R. Riley of the UCLA Law School and Director of UCLA's Native Nations Law and Policy Center. She directs the JD-MA Joint Degree Program in Law and American Indian Studies and is the UCLA campus representative on issues related to repatriation under the Native American Graves Protection and Repatriation Act, NAGPRA of 1990. Professor Riley's research focuses on Indigenous people's rights with a particular emphasis on cultural property and Native governance. Her work has been published in the Yale Law Journal, Stanford Law Review, Columbia Law Review, California Law Review, Georgetown Law Journal, and numerous others. She received her undergraduate degree at the University of Oklahoma and her law degree from Harvard Law School. In 2003, she was elected to serve on her tribe's Supreme Court, becoming the first woman and youngest justice of the Supreme Court of the citizen Potawatomi Nation of Oklahoma. I'm delighted to have a colleague in the UC system in Professor Riley and look forward to what I hope are many productive collaborations. Last but not least, our third presenter will be Edward Halealoha Ayau. He is Oiwi, or Native Hawaiian. He was raised in Ho'olehua, Molokai, and graduated from the Kamehameha schools in 1982, the University of Redlands in 1987, and earned a law degree from the University of Colorado in 1989. He has led efforts to repatriate ancestral Hawaiian skeletal remains, funerary possessions, and sacred objects over the past 30 years as the executive director of Hui Malama Ina Kupuna o Hawaii, the group caring for the ancestors of Hawaii. Founded by traditional cultural practitioners Edward and Pualani Kanahele of Hilo, they repatriated and reburied over 6,000 remains and items from museums in Hawaii, United States, Canada, Australia, Switzerland, Sweden, England, Germany, and Scotland between 1990 and 2015, before formally dissolving in 2015. He continues to work on international repatriation as a volunteer for the Office of Hawaiian Affairs. And I should add that he is also looked to by many Indigenous peoples as a moral compass in their repatriation efforts and also a technical guide. He is the person who knows how to get it done, whether through federal law, international mechanisms, or just simple being human. He is a longtime teacher of mine and a dear friend for whom I have tremendous admiration and aloha. Welcome all. I'm delighted to hear that we can all hear from you. And I'd like to turn now to President Echo Hawk for your words. Thank you all so much. And Maeve, if we could, yeah, thank you.
Thank you, Greg. And good afternoon, everyone. I want to first thank the CAP Center for putting this event on and for each of your presence this afternoon. I'm very honored to serve on this panel along with these two distinguished panelists, Professor Riley and Mr. Ayau. Both of whom I've admired for many years. I consider them to be heroes of mine. And so I'm glad to be here this afternoon with them. My task is to explain the proposition that repatriation within the meaning of the Native American Graves Protection and Repatriation Act is an inherent human right. And so in the time that I have, I'd like to first define what is human rights, and then examine the body of human rights law, looking at modern international human rights law, as well as the NAGPRA statute. And I hope that my presentation will lead to the conclusion that both NAGPRA is a human rights statute, and repatriation, as defined in that statute, is not only a statutory right, but also an inherent human right. So with that, let me just dive right in here. What are human rights? It seems like we hear a lot about human rights on TV and the newspapers. We deplore human right violations in other countries around the world. We're willing to go to war to punish violators of human rights. But what are human rights? At first blush, human rights might seem to many to be an alien concept because they tend to come to us from the international realm, United Nations treaties and that sort of thing. And most of us here in the United States are used to our own Bill of Rights, that define the rights of the person. But actually, human rights are really a homegrown concept that is as American as apple pie. Just a simple definition of human rights is to say that basically this is a natural law concept that quite simply means that a human right or human rights are the fundamental freedoms that all human beings enjoy as a matter of right. And this notion stems from the idea that every person has inherent worth and that life is precious. And if we look in Black's Law Dictionary, human rights are, again, they're defined as, quote, the freedoms, immunities, and benefits that, according to modern values, especially in at the international level, all human beings should be able to claim as a matter of right in the society in which they live. The contents of particular human rights are elaborated on in international law. But before I get to international law, I'd just like to underscore the idea that human rights are really core values in the United States. We can look back on our history and see that our nation really sprang from the human rights principle, in that during the birth of the nation, the founding fathers were gripped by the proposition that each human being is endowed by sacred or natural rights that come to us from a higher source that can never be taken away by any earthly or mortal power. And that was a fundamental organizing principle for our new republic, because the idea of human rights in this context was very well understood by the first generation of American leaders. And they variously described this notion as natural rights, the rights of man, or the sacred rights of mankind. And indeed, it was the denial of inalienable rights of this nature by England that led to the American Revolution. And so in the Declaration of Independence, Thomas Jefferson memorialized these ideals that went on to animate the American nation. And he wrote, and I quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these rights are life, liberty, and the pursuit of happiness, that to pursue these rights, governments are instituted among men, deriving their just powers from the consent of the governed." So these values are core ethical values that animated our nation and still obtain to this very day. So we can see that our revolution was literally based on human rights and the denial of those rights by England, that we went on then on this organizing principle to found and forge a nation unlike any other that went before. And these values guided and have guided our great experiment in democracy. Indeed, in history, during the rise and growth of our democracy, these human rights precepts were upon the lips of the people at every important juncture in American history during the rise and growth of our democracy. And so these human rights principles truly are American as apple pie, and they form a defining characteristic of our democracy. It's true, our nation has not always lived up to these ideals, but in every painful detour, these core values have always impelled America to self-correct. So today we look at the contents of particular human rights. They are elaborated on and come to us from modern international human rights law. This is a body of law that has experienced rapid growth after World War II. There's two principal sources of law for international law. The first being the treaties and conventions and agreements among nations. And the second and oldest source of international law is what is called customary international law. That is the norms that emerged from the worldwide practices of nations around the world. Once they form norms, they become part of customary international law, and that's the other source of international law. In the United States, a norm in customary international law becomes enforceable as a part of our federal common law. So if we look at these two sources, we can see where the concept of repatriation fits. First, I want to look at the UN Declaration on the Rights of Indigenous Peoples. This was a declaration that was enacted in the United Nations in the year 2007, and it was endorsed by the United States in the year 2010. And the declaration basically drew from the larger body of modern international human rights law, looking at the treaties and norms and customary international law to come up with this declaration to lay out for all nations of the world the inherent human rights of Indigenous peoples. And the Declaration had two basic remedial purposes. One was to give Indigenous peoples the same human rights that the rest of humanity already enjoys and takes for granted under modern international human rights law. And the second purpose of the Declaration is to rid nations of the lingering ill effects of colonialism. And so the Declaration created, in 46 articles, a very comprehensive human rights framework for defining the human rights of Indigenous peoples worldwide, including the United States. There are two articles in the Declaration that speak to repatriation, Articles 11 and 12. Article 11 requires state to provide, and I'm going to quote here, effective mechanisms to provide redress for religious and cultural property taken from Indigenous peoples without their prior free and informed consent or in violation of their laws, traditions, and customs. Further, in Article 12, it lays out that states shall, quote, enable repatriation of ceremonial objects and human remains in their possession through fair, transparent, and effective mechanisms developed in conjunction with Indigenous peoples. So it's very plain that according to the United Nations, these rights, these repatriation rights form an inherent human right. We can also look to customary international law, that is the practices of nations around the world. And there we can see that for centuries, it's long been the practice among nations to protect the sanctity of the dead and the places of burial, as well as the rights of next of kin and the rights of society to ensure that every person gets a decent burial. All over the world, mankind in all ages, places, and cultures have always buried the dead with reverence, religion, and respect. And we can see that as one example here in the United States, in the laws of all 50 states and the District of Columbia, which protects the sanctity of the dead, places of burial, the rights of next of kin, and ensures that every person, whether they have kinfolk or not, are entitled to a decent burial. And so it is the treatment of the dead that is a mark of a nation's sensibility worldwide. And that's a norm in customary international law. It's very plain to me then that both as a result of being a norm in customary international law and Articles 11 and 12 of the UN Declaration on the Rights of Indigenous Peoples, that this idea of repatriation as it appears in the NAGPRA statute is not only a statutory right, but it's also an inherent human right. And indeed, when NAGPRA was being voted on the floor of the Senate, the late Senator Daniel K. Inouye said that NAGPRA is a human rights statute. And indeed, that's bolstered now by modern international human rights laws. We now know it today. And so it's very fitting and appropriate to view the right and the duty of repatriation through the lens of human rights. And I think that's important because it means that it elevates repatriation from merely a federal statutory right into a human right, which is bigger than a nation. It's the kind of right that no nation can take away without being branded an outlaw or a rogue kind of a nation. So this right, the human right of repatriation, it ranks right up there with the right to be free from slavery, from genocide, from torture, and now this right of repatriation for Indigenous people is among these kinds of rights that come to us from a higher source and that no nation can take away. So that concludes my remarks. I've tried to make a case to you that this idea of repatriation within the meaning of NAGPRA is not only a statutory right, but it's also an inherent human right. Thank you, Greg.
President Echo Hawk, thank you so much. Those framing words help us so much here to understand the nature of this conversation. And I have to say, frankly, to hear basic human decency in the way you frame it, I think we're beginning to get used to that again. May it stay with us. The notion that we collectively in our pursuits of the human share profound ideas and norms and laws, and that we're moving forward back into a place where acting on these things is possible yet again.
Yes.
Thank you for setting us off down this path, and I look forward to drawing you back into the conversation shortly. Okay, thank you.
Thank you.
And now, Professor Riley, we'd love to hear from you.
Thank you. Hi, hopefully you can see my screen and hear me okay. Hello, everyone. It's wonderful to be here. My name is Angela Riley. I'm coming to you from Los Angeles. I'm on the unceded land of the Tonga peoples, and thank you for having me here. And thanks to the CAP Center and to Greg, and thank you, President Echo Hawk, for those incredible remarks. I have been asked to say a little bit about how repatriation is working in the UC system, and some of you out there may be students or faculty or people who have connection to the University of California. So I'm going to talk a little bit about my experiences with that and give you some idea of where things are right now. So I wanted to just start by first just telling you a little bit about who I am and where I'm from. I often like to start presentations with people, with audiences where I can't see you, so I'm not sure where you are or who you are, but just to let you know a little bit about myself. This is a picture of Saddle Mountain. Saddle Mountain is actually behind me in this picture in Kiowa County, Oklahoma. This is where I'm from. Looking to the north down this road is Green Valley Cemetery, where much of my family is buried in a family plot there. And to the east is our 160-acre farm that I was raised on, the house where my mother was born and raised and where I was raised. Behind me to the south is Saddle Mountain and the Kiowa Comanche County line. And then to the west is Longhorn Mountain and Rainy Mountain, which you've probably heard of. So this is just a little bit about where I'm from. I've been working on repatriation issues really since the beginning of my career as a professor. So at this point, probably close to 2 decades. And I've been working at UCLA as the representative, the NAGPRA representative on our campus since 2010. But for reasons that I'm going to start to explain to you here in a second, things are starting to change. And I'll tell you a little bit about that. I wanted to just start by saying that a lot of what we deal with, of course, with NAGPRA and the repatriation context is about repatriating ancestors, funerary objects, and cultural property and cultural patrimony back to Indian nations. But I think it's important to also note that these are ongoing harms. These issues have not resolved. They continue to arise. And this is just one example. Just in the last few years, the development of the border wall on the border between the United States and Mexico continued to unearth graves, cemeteries, places that were pilgrimage sites, sacred sites, Apache warriors were buried here. And this was in violation of the Native American Graves Protection and Repatriation Act. But NAGPRA, like other federal laws, were waived by the Department of Homeland Security as having lower priority than what was considered to be the national security interest of building the wall. So this is just an example of how these issues just continue on into the future, and these human rights abuses. And I think, as President Echo Hawk has so beautifully set forth for us, these are human rights issues. You're probably, I've tried to move around so that the light is okay in my office. You're probably getting a little glare. So if I look more angelic than usual, you'll know why. So let me just say a bit about why we have to understand repatriation as situated within the context and the legacy of colonization. One of the really remarkable things to me, Oklahoma has a very unique history, and it has a complex history, and it has a not necessarily lovely history when it comes to Indian and non-Indian relations, even today. But the thing about it, Oklahoma, is growing up in Oklahoma, you can't not know that there are Indian nations in Oklahoma. You are aware of the fact that we were the Indian Territory at one point. How the settlement of Oklahoma happened is something that's taught in school. But one thing I found really remarkable when I moved to California was how little people in California know about the Indian history of California. And really, the more I've studied it and the more I've learned, become very disturbed at how devastating that history is, and how in many ways it's so much worse than what happened on the eastern seaboard moving all the way west. The drive in California for natural and cultural resources was at a fever pitch. There was, of course, gold here, there's water here, the ocean is here. It's a beautiful and incredible landscape in so many ways. So it was highly desired by non-native settlers. A result of this history is that in California, we have hundreds of tribes, and even today, many of them remain unrecognized. The tribes that are recognized, there were treaties that were entered into with California Indian nations that were lost and never ratified by the Senate. In the 1950s, Congress passed a series of termination acts to terminate Indian tribes, and this effort really started in California and was supposed to be a model to move across the rest of the US. Some of those tribes have been restored, but not all of them. Many of you are probably familiar with Indian indenture laws and related to the mission system, the enslavement of Native people in California, Native people who were put into missions and missionized and taken away from ancestral and Aboriginal lands outside of the village communities that they had lived in for time immemorial. Relatedly, of course, the boarding school process, which took Native Californians out of their homes and their families and their kinship structures and into boarding schools for assimilation, taking their native languages and culture, and other really violent and destructive policies. And even as some people, including one of my colleagues, Professor Ben Madley, has made the case of actual genocide happening in what is now the state of California. So when you understand repatriation, and when I talk about it within the context of the UC system, I think it's important to also have that long view and understand that there were some incredibly brutal practices here in California. Many people aren't aware that academic institutions across the United States, many of them have holdings of Native and Indigenous ancestral remains and funerary objects and cultural patrimony, much of which came to those museums at a past time. They could have come informally through someone, leaving their estate and not really categorizing or making it known everything that was in there, or sometimes amateur archaeologists or even academic archaeologists collecting things at a time when it was permissible. But as a result, there are museums and academic institutions that have these holdings that had them at the point that the NAGPRA in 1990 was passed. And so there has been a long period of time within which to repatriate those things, ancestors and other items, to Native tribes. And it hasn't happened in the way that it really should have happened. And in some cases, it's been quite devastating. This is the National NAGPRA website. So this is just to compare some institutions. So this just gives you a sense of, these of course are not all academic institutions, but it just gives you an idea of what some of the institutions are that have holdings and what their numbers are. You'll notice that University of California, Los Angeles is not on this list. We have had a really incredibly successful period of repatriation, a commitment to repatriation. My amazing colleagues, Professor Carol Goldberg, Dr. Wendy Teeter, and another colleague, Desiree Martinez, have worked incredibly hard over many, many years to effectuate the repatriation of many ancestors that had been within the holdings at UCLA. But not all of the UC campuses have been so forward thinking and so progressive on these issues. And you can see that in this list, the campus at the very top of this list is the University of California, Berkeley, which is of course within our UC system. So I want to just talk a little bit about some of the things that have happened just in the last few years that have really kind of changed the shape of what's happening in the UC system, and I think will continue to change it going forward. And I've been involved in a lot of this, so I'm not going to get into a lot of detail because these are statutes and they can be somewhat, tedious to sort of read and parse through. But I just want to give you an idea of the timeline and a sense of sort of what is happening and what's going to happen in the future. So if you just take repatriation and NAGPRA, the federal statute, as the starting point in 1990, we know that there's been now decades of time within which many of these things could be repatriated, and yet they haven't been. In 2001, California passed its own version of NAGPRA called CalNAGPRA, but it remained largely unimplemented due to a lack of sort of political will and funding sources. So just in the last couple of years, there was a bill introduced to the California Assembly called Assembly Bill 2836 to amend CalNAGPRA, and it's one of its core focus was to require changes to the UC policy. Because the University of California had its own repatriation policy, which largely was getting implemented at the campus level. So at UCLA, for example, we were implementing it in our own way with our own team, although always reporting back to a system-wide committee of the University of California Office of the President, which representatives from the campuses served on that committee. So I chaired the UCLA committee and served on the system-wide committee. When that law was passed in 2018, UCOP, Office of the President, decided to convene a working group to revise the University of California policy to be more in line with the bill. I was one of the members of that working group. That policy, through a long series of meetings and site visits, going out to campuses and consultations and field hearings and collecting feedback from tribes and others, issued an interim policy in July of 2020. So that was, of course, about 6 months ago. The policy was pronounced as interim partially because of the pandemic, just to make sure people had time and tribes had time to look at that policy. It was to be finalized in December of 2020. As we know, that was just a month ago. But in September of 2020, another bill passed the Assembly, which is Assembly Bill 275, which also relates to the UC policy and repatriation, and is therefore going to require changes to the policy that has now been created. And the working group has now been reconvened and will begin meeting again this week. So all of that is just to say that I think one thing hopefully that you see here is that there's a long period of time of relative inaction, and then recently a lot of action. And I am optimistic that a policy is going to be developed that is going to align with the interests of tribal communities and really give voice to Native nations. And I'll talk more about what I see as some of the challenges and some of the possibilities now. I'm not going to go into too much detail about some of these because they're really specific about the statute, but some of the issues that you may have encountered if you've worked in this area, issues of cultural affiliation, which were really key prior to some new regulations that came out that made some exceptions for affiliation. I won't go into all of those right now. Unfunded mandates, much of this work was directed by statute, but was not funded adequately. So institutions had to take it upon themselves to really commit the resources to effectuate these repatriations. And I have to, again, give a shout out to my colleagues at UCLA who really worked very hard to marshal the resources to do that on our campus. The devaluing of Indigenous peoples' knowledge and oral traditions has been a key issue, and I think it's something that's meant to be addressed by the latest bill. But that is in part to make sure that Indigenous knowledge is valued at the same level as what sometimes gets phrased as an oppositional source of knowledge, such as scientific knowledge or academic knowledge, as if those things don't coexist. And so really giving life to oral tradition and other Indigenous knowledge. Restrictive definitions. There are definitions in NAGPRA that have made it difficult to repatriate, for example, an item or cultural item that's not used in a contemporary ceremony. If it was used in a ceremony past, it might not qualify for repatriation, even if the ceremony no longer is being conducted because the tribe no longer has access to the ceremonial objects. So there are definitional issues. There are problems with evidentiary standards and where presumptions lie in terms of where weight goes in balancing interests, not having real consent from tribes, and again, sort of views that archaeological knowledge is superior. Let me just say a couple of things that I think really begin to address this as a human rights issue. One is implementing free, prior, and informed consent, which is known as FPIC, which is contained in the UN Declaration on the Rights of Indigenous Peoples. So not just telling Native people what is happening, but truly consulting with them on a nation-to-nation basis and really abiding by human rights standards with regard to consent. Changing some of those legal standards and presumptions, taking Indigenous peoples' knowledge seriously, funding obligations on the role of the nation state. This is really important. The money piece is always something that people don't necessarily want to talk about, but it costs a lot of money to make sure that you have adequate staff and knowledgeable staff and people who really have the time and energy to engage with tribes. Grants and other monies that are available for tribal communities to be able to come to campuses and be in conversation with museums. Many tribal communities don't have the resources for that, and there's been far too long a burden put on Native communities themselves to come up with the information and the knowledge and the money to come and actually get their own ancestors home. And that just isn't always possible. To decolonize Indigenous rights, take a broader view, move out of some of the genocidal and historical framework that we've been working within, really acknowledging the religious freedom of Indigenous peoples, which many of you, if you work at all in this area, know that there are still just inadequate protection for and respect for Indigenous peoples, religion, for understanding that religion is different in Indigenous communities. It relates very directly to lands and to the earth and the connectivity of all things on the planet. And then, of course, in the US context, really respecting self-determination and tribal law and having that nation-to-nation relationship with Native nations is also another big piece of this puzzle. So I just want to close by saying Jaginaginan. This is a Potawatomi word that means all my relations. These are for sacred places to Native people here in North America. And so that just gives you an overview of sort of what's happening in the UC system with an eye towards, I think, a brighter and more cooperative future. So with that, I will conclude and turn it back to Greg. Thank you.
Thank you, Professor Riley. That was so powerful, and I'm so moved by how the conversation has gone from the maximal level of universal human rights, drilled right down to our institutions here in California, but with the same language, the same ethos and norms being advocated for. The way that's touching down moves me, and I hope it moves the rest of you as well. Indeed, brighter days are ahead. A note, we have a lot of viewers right now, and I'd like for you all, when you have your questions, to put them together, get them in the Q&A prompt, and we'll do our best to get some of them. But before we do that, we have our third presenter, Edward Halealoha Ayau, again, a dear friend. And Hale, it's such an honor to have you with us and bring us home. Thank you.
Mahalo. Let me start off by thanking Professor Greg Johnson for the invite. And aloha to my fellow panelists, to Walter Ekohawk, who really inspired my work. When I was a law student, I clerked for him, and I got to work on 2 Pawnee repatriation issues, and that really opened my eyes to a similar problem that was happening to Hawaiians. And I've spoken, in fact, I think the last time I was at a conference with Professor Riley was in Canada at the UN MRIP last March, I believe. So it's always an honor to be included in these discussions. Let me just dive right into it. So I am a product of my ancestry. I am the son of my kupuna, and my parents are Reynolds, Lealoha Ayau, and Muro Monike Ala Ka'eo. Okay, next. I am a product of my education. Besides going to formal education schools and law school and clerking at the Native American Rights Fund and working as a staff attorney at the Native Hawaiian Legal Corporation, I was able to begin studying in Hawaiian cultural and spiritual practices regarding the care of iwi kupuna. And that was with my kumu Edward and Pualani, Kanaka Ole Kanahele. And you know, that really changed my life, and it changed my view of how to use all of this education to engage in repatriation activities. And I also wanted to mention that in my years at NARF, Walter and the others really taught me the mantra to stand firm for justice. It's not just a saying; it's a strategy. It's a way of life, if you will. Okay, next. A lot of my work was done through a Native Hawaiian organization called Hui Malama Ina Kupuna o Hawaii. We were created from grief and despair. Back in 1988, when a private landowner exhumed 1,100 ancestral Hawaiian graves for a parking lot. The organization was then formalized. It was identified in state law and then included in both the National Museum of the American Indian Act and the Native American Graves Protection and Repatriation Act as a qualified organization to engage in consultation and repatriation. But our work was intended to be interim. We weren't considered the solution, because really the solution is restoring awareness to the na'au, or the inner understandings of our people, to reconnect them to the family kuleana of caring for their ancestors' remains and their funerary possessions, restoring that awareness to their conscience. Our work involves not just in the U.S. but abroad. The location, identification, negotiation, and repatriation of over 6,000 of our ancestors' remains. And we've been doing this for the last 31 years. In 2015, at the instruction of my kumu, I dissolved the organization. And I remember being told by an elder at a meeting once that she was scolding me and telling me I couldn't do it. And I said, "What? Why would you say that?" And she says, "Well, who are supposed to take care of our ancestors if you guys don't do it?" And I said, "Actually, that's every family's responsibility, not ours." And so we are at that level where we got to take the training wheels off, and all of our families have to step up and be responsible. All right, next. So in our practice, over the last 31 years, we learned to empower our mind and our spirit by inviting our ancestors to guide and empower us. So this was super critical. I always share this so that people understand that the work that was conducted wasn't just on the human side. Yeah. So we were taught to use our ancestors. People used to scold us and go, "Don't you use your ancestors?" We were taught to use them because they want us to, by uttering their name, by asking them for help and guidance, by placing them back in the position of supporting the family once again. They live on. So this is one of the main lessons we were taught by our kumu, and this idea of them living on after death. This notion of everlasting life is it's not unique. Our indigenous peoples always did it, always understood that. Okay, next. So repatriation is most certainly a human right, but it is also, in our practice, an indigenous responsibility. And so it's not so much that we are entitled to the iwi kupuna, the ancestral remains, as much as it is that we are solely responsible for them. And in the Hawaiian language, this is best explained by the word kuleana. Kuleana, interestingly, means duty, responsibility, but it also means privilege. So you know how in English, duty, responsibility is one thing, privilege, rights is something else. But in Hawaiian, they're one and the same. And the reason, and the way that works is one gains privilege by being dutiful and responsible. So this whole idea of entitlement that a lot of people have is really this a disease of understanding. We're not entitled to it. We earn it through responsible behavior. Okay, next. So museums are quick to assert their perceived entitlements whenever we make a claim, and we would respond by saying to them that the well-being of our ancestors, of the iwi kupuna, is a matter of kuleana, and that this duty includes the responsibility to respect the original intent of the family to commit their family members to the care of Papahanau Moku, which is our word for the Earth Mother. Yeah. One thing that would always make me uneasy is when there was this discussion of ownership. Under like the common law, there's no ownership of human remains, but museums, oftentimes when you deal with them, that's what they're talking about is we have them, therefore they're ours. But it took me a long time to come to the realization that in effect, there is an ownership understanding in Hawaiian. And that is that the iwi doesn't belong to the family. They belong to Papahanau Moku. They belong to the earth. Once they're committed to her realm, if you want to discuss an ownership, issue to this, they are then under Papahanau Moku, under our Earth Mother, and certainly not a museum. Okay, next. So we assert that we're the only ones who possess these duties. And therefore, unless there's clear indication of the family's intent to give their ancestors' remains away, the acquisition is de facto theft. We therefore focus and advocate legal principles, including, as Walter had mentioned earlier, free, prior, and informed consent. And this is the best part, which the museum has the burden to prove, not us. If our families placed them in the ground and you now have them, then it is your burden to prove that you have family permission. And in 31 years of work, that has never been demonstrated. Okay, next. Here's a table of just the international repatriation cases that we've done. Although because Hawaii was an independent kingdom, we even considered NAGPRA to be international because if we're bringing them from outside of Hawaii. But these are the foreign countries, from Switzerland, Australia, Canada, a lot of work done in England. And so in these cases, we didn't have the benefit of American law, of NAGPRA. Yeah. But what we were able to do was to explain and advocate on behalf of our kupuna as a matter of duty. That it is our duty as a living descendants to care for those who came before us. And the most recent case we did was the Duckworth Laboratory at Cambridge University, which I'm going to mention a little bit later. Okay, next. So whereas museums seek to take from our ancestors, right? So when you ask them, why do you want to keep them? They say, oh, because we want to glean information from them. We want to find out about diets, about migration patterns, you know, all of these things, which is the act of taking from them. But in our work, we view it as seeking to give back the ancestors their place in the family, yeah, in the Ohana. Okay, next. We assert that there is no room at the family table for the museum's asserted rights to continue the taking, which at the very best is the ill impacts of colonialism. So, you know, the difficulty in this work is that you're having to relive colonialism, you know, except this is the 2.0 version. Different time, same story. And that's why it's important to advocate, you know, your values. Okay, next. So in the respective expressions of humanity, the fact that we seek to restore our family says something about us, and the fact that museums seek to maintain the separation, keep the EV away from their families, says something about them. But you know, it doesn't have to be this way. It doesn't. And I think over the last 30 years, you've seen this real maturity of approach by a lot of museums, which is not to say they all, matured in their thinking, but a lot of them did, and very significantly. So good for them. Next. You know, our initial approach to repatriation when we first started, because we were much younger then, was to force the return, bend the museum to our will. I particularly enjoyed that part and those years of really, you know, putting it to the museums. But that view, well, that's not a sustainable approach. It's what I've learned. And that view progressed as we matured in our thinking to a more enlightened approach whereby we work toward a solution that involves the museum. Yeah. So that there is some, you know, we'd always tell the museums that repatriation isn't the end of the discussion. It's actually the beginning. And that the information that we can share about our culture, about the items that you have, is enriched by this relationship. All right, next. Up next. Okay, so there was a strategy change. Yes, so in order to maximize the effectiveness of our advocacy, we learned to be mindful that other Indigenous groups would be traversing this same trail with this museum. Cambridge University is a good example. We had every reason to just take it to them. But we had to be mindful that the rest of the Indigenous community had pending claims as well. And so the goal expanded from repatriation to also include the duty to enhance the relationship with the museum and not to undermine it. So there went all the fun. Ultimately, this is about human beings acknowledging their respective humanity and recognizing the imperative of mutual respect, fueled by what former President Obama phrased as the audacity of hope. Okay, next. You know, I'd be remiss if I didn't mention this. So culturally, we had to be taught to protect ourselves from the psychological, the spiritual, the emotional harm, what Hawaiians call kaumaha, that's inherent in the revelation that our ancestors were stolen. So we've done over 120 of these cases, and each time when we were exposed to information that an infant was taken, or a mummified arm was removed, or whatever horrific, you know, story is involved, it causes anguish. It causes harm. And we had to be taught how to protect ourselves from that harm. Yeah, and it wasn't easy. And we were fortunate that we had Kumu who had the right knowledge to know how to process that information so that we can stay clean from it and stay healthy. All right, next. And strategically, our principal weapon in repatriation disputes is our Hawaiian humanity, as Walter mentioned earlier, our values. That is, when people say, well, how is it that you're able to bring remains back from Germany and England and Australia? I would always say, there's no statute of limitations on Aloha. There's no statute of limitations on Kuleana. There's no statutes of limitations on Malama, on caring. Like, we can assert our cultural values anywhere in the world, in any jurisdiction. Because the bottom line is, this is a family matter. Those are our family members, and you're in possession of stolen remains. And how we traverse and navigate through those issues reflects on our respective humanity. Okay, next. We were trained to initiate a repatriation case by envisioning the result. So you start by envisioning the result, which is to say we would envision the reburial. And then we'd work backwards from there with a confidence in knowing how the case would turn out. I always tell museums, I would show them the list of 100 or so repatriate and the names of all the museums that we repatriated from. And I would tell them, your name is going on next. And they would laugh and they were like, yeah, sure. And I was like, no, it will. And they all have, whether they believed us at the time or not. But it comes from that training. It's from knowing that in order to make things pono, in order to make things right again or righteous, is to restore them to their original condition. Okay, next. We learn to project confidence and clarity of thought through our advocacy work. So perseverance is key because the clear result of repatriation or reburial does not come with a timeline. So I cannot tell them when that's going to happen. I just can tell them that it's going to happen. And some of our cases, the longest case with Dresden took 26 and a half, almost 27 years. But those ancestors came home. So again, it's not whether they're coming home, it's when, but we cannot tell you when. Okay, next. This was mentioned earlier about national repatriation work that was done through NAGPRA, which Walter and Jack Trope were part of creating, establishing. But there's no equivalent legal authority in the international arena. It's a case-by-case basis based on the jurisdiction that the museum is in. Okay, next. As was also mentioned earlier, since 2007, with the passage of the UN Declaration on the Rights of Indigenous Peoples, we asserted these rights in the international cases as a context to effectively frame the dispute, between the museum and ourselves as a claimant. Okay, next. Did you skip one? Oh no, okay, next one. And so I wanted to share this quote. This is by, these are the words of Papa Mau Piailug. Papa Mau was a Micronesian master navigator. And he trained the 5 pole navigators, Hawaiians, who demonstrated their training and their learning, their expertise by sailing our mother canoe, Hokulea, around the world in 2017 without the use of navigation equipment, right? Just celestial navigation. And he said, if I have courage is because I believe in the knowledge of my ancestors. And I love this quote because it sums up, our approach to our work. If I have courage, it is because I believe in the knowledge of my ancestors. Okay, next. Oh, this is it. So this and the next slide is just a list of the first 50 something repatriations that we did. But if you look on here, I think number 17, the Phoebe Hearst Museum, University of California, Berkeley. So that was our first, that was the first appeal of a NAGPRA decision. And it was heard in Hawaii, and we appealed the museum's refusal to return to Hawaiian skulls to us. And ultimately we prevailed, and they were both repatriated. But it gave us insight into Berkeley. And now 30 something years later, we are repatriating from Berkeley again, because they found more ancestral Hawaiian remains, which is a common problem that we faced over the past 30 years. So with that, I just wanted to say thank you, and I look forward to our discussion. Mahalo.
Mahalo, Halealoha. Thank you for your words. I think everyone could see and hear how the principles that President Echo Hawk articulated and Professor Riley brought to bear in the university system here at California so animate the kind of work you've been doing. And I want to ask you if you'd indulge us in a story about, you mentioned the Dresden Repatriation, that it took fully 26 and a half years. And what strikes me about that case is none of the legal mechanisms that have been mentioned were suitable for various reasons. And you appealed to your basic sense of humanity and their basic sense of humanity, and then set a precedent, as I understand it, for how they would treat other Indigenous peoples. Could you just walk us very briefly through that encounter and how you understand that precedent going forward? And of course, mechanisms do need to be put in place so that people like you don't have to help museums reinvent the wheel at every turn. But I was struck by, after years of bureaucracy, how you were able to speak through that mess, gain some clarity from them that they say will carry forward. Tell us a little bit about that.
So I think it was around 1991 when we learned that this museum, the Ethnological Museum in Dresden, Germany, had 3 sets of Hawaiian remains, and we made a request to repatriate them. We also went to Washington, D.C. to meet with the German embassy. We asked the U.S. State Department for help, and we got that through support of Senator Daniel Inouye and others. But in the end, the museum kept saying, no, they are our property. The German National Science Commission or whoever they are stepped in and said, no, these are of scientific value, and we will not give them back. And so we just kept trying, kept trying. So fast forward, Germany, the museum, the National Museum Association developed a set of recommendations to guide German museums in when they receive repatriation claims from both within Germany and more, as well as international claims. And my colleague, our colleague, Honor Keeler, had reached out to me and asked me if I'd co-author a response to that. And I was like, no, why would I want to do that? They just, treated us really horribly, including telling us to our face that they were the remains were their property, which really hurts. But she, Anna Keeler, she can be convincing, and she convinced me, and we responded. And in that article, I referred to the German officials and all of their, responses to us as an example of what I call intellectual savagery, because they were using their intellect to deny us our humanity. and that was the savage nature of their intellect. Well, that article was brought to the attention of a senior curator at that museum, and who had no idea after all these years that we had been requesting repatriation. And she met with internally with the director and the other museum leaders. Then they had a conversation with their national leaders, and ultimately made the decision to repatriate the remains to us in October of 2017. And as you know, you were with us on that trip. We were able to go there and take possession of them. And equally as important, to publicly acknowledge the role of sitting across from each other and speaking to each other as human beings. Not, so part of their concern was, is this guy going to blow up during the public, because of all the things we said to him. And it was just a sign of maturity. But that was the last thing on my mind. Who wants to look back? I wanted to make sure, one, that there was an acknowledgement that they understood the importance of returning these ancestors to us, but also that they understood their duty to the rest of the indigenous people whose ancestors they had. And so they since repatriated to the Maori. They're working with the Australian Aborigines on their repatriation case and with Native Americans. So that's, and it's actually started a very intense, if you will, discussion within Germany amongst the museums, because not all of them appreciated what Dresden did. And they did it in a national, it was very, in a very public fashion. And so our current work over the last year, even though things have been shut down with COVID, has been to focus on several institutions in Germany, which we are queuing up for a repatriation trip, hopefully at the end of this year or the beginning of 2022.
Mahalo. It was so powerful to see that unfold. So thank you for sharing that. We have a number of really excellent questions, and what I want to do right now is invite Professor Riley and President Echohawk to take a look at those questions. Some are of a technical nature, and to see which you might want to answer. I can read them aloud, of course, but if you could just take a look while I ask Halealoha one more question here, and that is, Halealoha, you're in the middle of a ritual context right now. We're so grateful you took time out of that. Could you just tell us the nature of the ritual insofar as you're able to share it, because it's historically important, it's important today, it has everything to do with the rain we're all experiencing.
Right. So this is our Makahiki season. This is a time when the rains come, when the constellation Makali'i, the Pleiades, rises over our horizon. It lasts from end of October, beginning of November to around this time. It involves one of our four principal gods, Lono. So this was the god that when Captain Cook shows up, the Lono practitioners of that time say that he was the embodiment of that god. And it's the ceremony, we're going to carry the Lono staff from one end of our island, I'm on the island of Molokai, from Halawa, all the way across the island to Halealoha, which I think in all is going to be about 45 miles. And different members of our community are going to participate by carrying Lono and reminding us that, as my sister Mikiala Pescaya put it, blessings are earned, and to pray for the rains to continue returning, pray for abundance and for food, especially during this really difficult time. But it's part of our annual Makahiki.
Thank you, Mahalo. That's
Yep.
I love to hear that, but also it's important. We have many students tuned in, and I think tying together so much of what has been said this afternoon with just the simple but profound notion that living traditions are unfolding in the present, right? You're out there doing it, and that should go without saying, but we all know how easily that gets lost in the thicket of social media, of assumptions in our education and so forth. And so mahalo for sharing that.
Well,
Let me invite Professor Riley and President Echohawk back in, and I want to be cognizant of time here, but also to invite you to share words with one another if you had something you wanted to build on that the others had said, or challenge if that might be the case. And then if we have time remaining, we can get to a question or two, and apologies to the audience that we won't get to all of them, but I'll just open it up to you all. Professor Riley?
Hello, Greg.
Yeah.
Oh, go ahead.
Yeah, no, please, one of you say something.
Okay. I would just like to interject a quick remark or two to follow on both Halealoha's remarks as well as Professor Riley's, and to also to say I can't access the questions, so I'm going to have to rely on Professor Riley to take the lead on that. But I was very moved by Halealoha's remarks. The repatriation quest on the part of Indigenous peoples is at bottom a spiritual journey, where you have one foot in the spiritual world and one foot in the material world. And I've always been moved by the Native Hawaiian culture, very powerful people. And we share a lot of values and traditions, I think, with our Native people here on the mainland with them. And so I was very moved by Halealoha's remarks. And as to Professor Riley's description of the UC system, it appears that this UC repatriation system is a very long-standing problem. The NAGPRA law was enacted in 1980. That's 41 years ago. And yet today the UC system still houses untold thousands of Native American human remains and funerary objects. And that seems to me to be a very inordinate amount of time in which to comply with this federal statute. And they always say, justice delayed is justice denied. And so I hope that this human rights principle will light a fire under the UC system to comply with this federal statute as a human rights matter, because it's very apparent to me after 40 years that the UC policies, whatever they may be, that are in place simply are not effective mechanisms to repatriate these remains to the tribes. And so, if the idea of repatriation is viewed through the lens of human rights, it would see, and especially, Article 12 of the UN Declaration, that you would expect a much more speedy and effective mechanism to get this done. And so I'm just hoping that the UC system will look at this matter through the human rights lens, and act swiftly and promptly to comply with the law, and not cause these contortions. And NAGPRA was enacted because it would take 40 or 50 or 60 years to repatriate an object. And so I just am very, I just want to say shame on you. We're taking this long. Let's look at this as a human rights matter. We deplore human right violations, and so please UC system, let's march forward in the human right era and take heed. So that's all I wanted to say, and I'll turn over the to Professor Riley.
Well, thank you so much. Yeah, just to respond to that a little bit, I mean, I completely agree. And I guess just a couple of points. I mean, one is that, you know, there were a couple of more offending campuses than others. And I don't know, you know, I wasn't here when any of this happened originally. My understanding is part of what happened is that NAGPRA, when NAGPRA was passed, many of these institutions actually already had enormous holdings. And then in order to meet the inventory mandate of NAGPRA for things that they couldn't clearly identify, they designated as culturally unidentifiable. And by doing so, there weren't mechanisms for repatriation of culturally unidentifiable for almost a decade later. And then there have been issues about putting in the resources to revisit original designations where things actually can be culturally identified at this point. So you're right, it has been a really a problem of enormous gravity. And I think that's what inspired some of the recent legislation in California. And I do think, I guess 2 points to that. One is that I have felt, and President Napolitano, when she put this working group together before she stepped down, you know, had an enormous desire to flip the presumption and to essentially say, it is time, things should be repatriated now. We can't make up for what's happened, but let's really make an effort. And the people that were convened were like-minded in that charge. So the policy that resulted, I think, is meant to achieve those things. But then I guess the other point that kind of goes against what I'm saying, although a policy isn't really law, which is to say law can only do so much. And I think Eddie's work has been so profound, and part of that is showing that relationships and diplomacy and advocacy and commitment and deeply, deeply held beliefs that are unwavering for Indigenous peoples to continue to pursue justice sometimes are more powerful, much more powerful than what the law can do. And law also gets implemented by people. And I think part of what we saw at least in some pieces of this story in the University of California system is that there were people who were empowered to examine the law and apply the law, and they put their own spin on it. And if they didn't have a commitment to repatriation, then there's a way to manipulate law. So I think that we're seeing a whole new generation of people put into these positions who have those commitments, and with shifting definitions where presumptions are in favor of repatriation instead of against, where Indigenous people's own knowledge is actually given the weight that it is worthy of and deserves. Those things are happening, but I agree with you. It is taken far, far, far too long. But I also have to express my deep gratitude to you both for the work that you've done and really just being enormous sources of inspiration in your own ways to all of us who are following in your footsteps and trying to continue this good work. So miigwech to you for that. Thank you both.
Thank you. One question I can answer myself directly: is this being recorded, and where might you find it? Yes, it's being recorded. So it's on Facebook Live. So it'll be on the Walter Capps Facebook page. You can find it there, but also it will be archived as soon as tomorrow, I hope, if not the day after, on the Walter Capps video page. Online, you can just Google us, the Walter H. Capps Center, and you'll find it right away. So thanks for that. Thanks to our presenters for allowing for that. I think these are terribly important conversations that many students, among others, will benefit from. I understand President Echohawk doesn't have access to the questions. We only have a few minutes anyhow, but Professor Riley, could you see them? Or Halealoha, could you see them? Some are of a technical nature, but if there are any that you wish to address immediately, please jump in. Or if you prefer that I do triage.
I'll just quickly say that there were a couple of questions about definitional issues and also implementation. of new laws and policies. And I think one of the questions is sort of about the extent to which, traditional knowledge or Indigenous people's own knowledge will be given weight. I think when NAGPRA was first passed, I think there was a bias very much in favor of what was considered archaeological knowledge or scientific knowledge. Over the years, that began to at least balance out a little bit, where there was more credibility given to Indigenous knowledge. And now I think at least the purpose of this new statute in California, my guess, and we haven't met yet to discuss it, my guess is that one possible consequence of that statute will be to actually weigh Indigenous knowledge more heavily than the institution's assertion of knowledge and ownership. And so, but it'll be interesting to see how that happens in the final policy. But that is my understanding, one major impetus behind the passage of that law. So we're going to be, rubber will be hitting the road on that. But I think those issues have prevented repatriations in the past, for sure.
Thank you.
And I think in our experience, we get faced with that sort of dynamic every time we deal with the museum. And the first thing we do is, reframe and make it crystal clear to them that we're sitting at a family table and you actually don't have a seat. This isn't about your science, because, for over 30 years, I would go to different Indigenous communities to speak, and I'd always do this survey. Raise your hand if you think your ancestors mated for the purposes of creating osteological material. No one ever raised their hand, which means that's not what they were, that's not why they gave birth and why we had our cultural societies. So why are we even having this conversation? And we would just hammer away until they realize that the table, the conversation is already skewed in their favor. And our job was to make sure that they understand that there is a family, that this is a family matter. We're representatives of that family. And we need you to understand how offensive it is that you are asserting, these, secondary, tertiary beliefs. Props to Cambridge University. When they made their decision, they included a formal finding that said that they recognize the right of Native Hawaiians to assert that they have no responsibility to science to advance the knowledge of our people by allowing the exposure of our ancestral remains. Which is not to say that we're not going to participate in the promotion of knowledge. But if you want to know about ancestral Hawaiians, talk to us. We're the living embodiment of those very ancestors. And to try and just get them to return to their own family roots. Because I think once you do that, they see the world in a whole different light. And if it doesn't work, then fight with them.
Mahalo.
Too.
Yeah. No, mahalo. Well, I'd like to invite President Echo Hawk to have the last word here. We're about out of time, and Halealoha needs to get on his ritual way. But President Echo Hawk, if you had any parting reflections for us, I'd like to invite you to share, and then we'll call it an evening.
Well, I want to thank you, Greg, again for the opportunity to participate in this, and thank you and the CAP Center. It sounds like you're having a wonderful symposium, and that's very important to our democracy and our free and democratic society. And I appreciate the opportunity to be here in California, and once again to be here with two of my heroes, during the course of my life. And just to say that, it's really a wonderful opportunity for us to talk to your audience about what is a universal human rights value and sentiments with regard to our dead and our departed and the responsibilities of the living, to the dead. And so I thank you for that. And I'm joining the rest of our nation, I think, and looking forward to better times in the days ahead in 2021. And I hope they come soon. So thank you very much.
You're very welcome. I want to extend my gratitude to all three of you. This has been terribly enriching for me. I know it was for my colleagues and students. I think it's of a piece with the larger challenges we face of just being better humans today and finding ways to make our democracy pay good on that. So thank you all. Thanks again to the staff here at the CAP Center, most of all the audience. Everyone have a good night. Halealoha, we wish you well on the Makahiki. And Professor Riley, you can count on me bothering you for more UC things in the near future. And you all take care. Aloha to everybody. Have a good night. Thank you.
Thank you, everyone. Bye.